Hey guys, let me ask you, are you Three Scoop enjoyers as much as I am a Three Scoop enjoyer? We celebrated Donald Trump's 3 SCOTUS scoops all those years ago, and now we're seeing our celebrations were just and righteous. Could you imagine had Hillary Clinton won the 2016 election and she had the chance to nominate 3 activists to the court? Could you imagine a court filled with Sotomayors and Ketanji Brown Jacksons? It would be a complete disaster. But thankfully enough, that isn't the case. That never happened, and the actual reality here is the potential saving of American democracy from the exact people who constantly claim that their number one goal and priority is to save American democracy from the evil fascist tyrant that is Trump. Donald Trump's 3 Scoop SCOTUS, the Supreme Court of the United States once again delivers and delivers big. This time in oral arguments, they're asking all the right questions, and Trump's lawyers seem to be performing admirably as well. We gotta talk about the oral arguments that just happened on the issue of presidential immunity at the Supreme Court of the United States. All the right questions are being asked, which of course has leftists in a complete panic. Let me show you guys exactly what I mean by that. We got some stuff to get into, so let's roll the tape. Alright folks, so I like to think of myself as logical, as a rational human being. I like to think that when I hear 2 sides of an argument, I have the ability to put my finger on what sounds nuts, what sounds completely insane or unsustainable, and what sounds clearly logical. What's the common sense approach? And on this issue, I think it's quite clear. Trump's lawyers are arguing in front of the Supreme Court that he, as a former president, explicitly in the actions that he took as president, should, to a certain extent, be protected by presidential immunity. And of course, the initial expected pushback from leftist SCOTUS activists is going to be something like this.
George Washington. Framers did not put an immunity clause into the Constitution. They knew how to. There were immunity clauses in some state constitutions. They knew how to give legislative immunity. They didn't provide immunity to the president. And, not so surprising, they were reacting against a monarch who claimed to be above the law. Wasn't the whole point that the president was not a monarch and the president was not supposed to be above the law?
I would say 2 things in response to that. Immunity, they did put an immunity clause in a sense. They put in the executive vesting clause, which was originally understood to adopt a broad immunity principle that's set forth in the very broad language of Marbury against Madison. And also, they did discuss and consider what would be the checks on the presidency. And they did not say, we need to have criminal prosecution. Right there at the Constitutional Convention, Benjamin Franklin says we don't have that. That's not an option. Everybody cried out against that as unconstitutional. The structural check we're adopting is impeachment. And they're very clear on that in pages 64 to 69 of the 2nd volume of Farrand.
Thank you.
Wouldn't there be a significant risk that future presidents would be emboldened to commit crimes with abandon while they're in office? It's right now the fact that we're having this debate because OLC has said that presidents might be prosecuted. Presidents from the beginning of time have understood that that's a possibility. That might be what has kept this office from turning into the kind of crime center that I'm envisioning. But once we say no criminal liability, Mr. President, you can do whatever you want, I'm worried that we would have a worse problem than the problem of the president feeling constrained to follow the law while he's in office.
I respectfully disagree with that because the regime you've described is the regime we've operated under for 234 years. There has not been an expectation based on 234 years of unbroken political.
All right, let me ask you another question.
The president cannot be above the law. If we declare that the president is immune from prosecution, what kind of message is it going to send to other presidents who want to act illegally? This is the expected pushback. And of course, if you ignore all nuance, you might be susceptible to agreeing with this argument, but there's only one problem, which was highlighted by Trump's lawyer, that actually presidential immunity has kind of been the game. It's been the status quo forever. That's been the regime. Yet presidents don't feel emboldened to break the law willy-nilly as they see fit, expecting they're never going to be held accountable for their actions. That's where impeachment comes into play. The whole point is for presidents to be able to operate with a certain level of impunity, to have the ability to make extremely difficult life and death situation decisions without fear of prosecution. Then, of course, if a president is to do something that is so horribly wrong and illegal, well then the authority lies specifically within Congress to democratically, through a supermajority vote, to be able to impeach the president for committing a high crime or misdemeanor. The structure's already in place. Presidents do benefit from a certain level of immunity in order to protect them from being prosecuted by rogue attorney generals and federal prosecutors operating on behalf of the opposing political party's political demands. It's really not complicated stuff. And of course, Trump's lawyer made that exact argument, and it simply makes sense.
Mr. Chief Justice, and may it please the court, without presidential immunity from criminal prosecution, there can be no presidency as we know it. For 234 years of American history, no president was ever prosecuted for his official acts. The framers of our Constitution viewed an energetic executive as essential to securing liberty. If a president can be charged, put on trial, and imprisoned for his most controversial decisions as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. Every current president will face de facto blackmail and extortion by his political rivals while he is still in office. The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure. The original meaning of the executive vesting clause, the framers' understanding and intent, an unbroken historical tradition spanning 200 years, and policy considerations rooted in the separation of powers all counsel against it. I welcome the court's questions.
Without presidential immunity from criminal prosecution, there can be no presidency as we know it. If a president can be charged, put on trial, and imprisoned for his controversial decisions, as soon as he leaves office, that looming threat will distort the president's decision-making precisely when bold and fearless action is most needed. I don't know, am I the crazy one, or does that make sense? And is it just me, or has every other president in American history been protected by presidential immunity except for Donald Trump? There's a standard for everybody else, and then, of course, there is a standard for Donald Trump. The legal argument coming from the left is that Donald Trump's motives were different. He wasn't operating on behalf of the interest of the nation. No, for him it was personal. That's what left-wing Justice Sotomayor essentially implied.
It can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say, if you stay by it, if the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain.
But how can that possibly be the case, or how can that be the basis of charges against a president? You know, the whole thing is built on an assumption of motives. Neil Gorsuch actually tackled the issue.
For sure.
Justice Gorsuch, right? Can I try one more time?
Well, let me just spin this out just a second, okay. Right? And it didn't matter what the president's motives were. We're not going to look behind it.
Right.
And same thing in Nixon. We said, gosh, Nixon versus Fitzgerald. That's something courts shouldn't get engaged in because presidents have all manner of motives. And again, I'm not concerned about this case, but I am concerned about future uses of the criminal law to target political opponents based on accusations about their motives.
These cases and these prosecutors can't be dealing in assumptions of motives. The assumption is that Donald Trump was acting only for personal gain because he wanted to personally be a tyrant and use his power to remain in office. What a ridiculous assumption. How can you even prove that? How can you prove what somebody was thinking in their own mind retroactively? Well, you clearly can't. And the alternative is that President Trump, based on his view and his expression and how many people around him have suggested, he was acting purely in the interest of preserving and saving American democracy because he felt as though something corrupt and wrong had happened. He was acting, in his view, to preserve American democracy rather than destroy it and overthrow it. Any argument to the contrary is simply an assumption. Frankly, they're both assumptions. The question is, how do you prove it in court? Well, obviously you can't, and obviously it shows you how ridiculous this case is. Presidents should not have to worry in their decision-making that they might at a later date face criminal prosecution based on assumptions of what they meant with their behavior or decisions. That simply cannot be the legal standard. Then, of course, there's more double standard. Another important question that I think everybody ought to be asking themselves: why Trump? Why is it always only Trump that seems to be facing this sort of persecution? That's a question that Clarence Thomas asked quite clearly.
Over in not so distant past, the presidents or certain presidents have engaged in various activity, coups or operations like Operation Mongoose when I was a teenager, and yet there were no prosecutions. Why? If what you're saying is right, it would seem that would have been ripe for criminal prosecution of someone.
So, Justice Thomas, I think this is a central question. The reason why there have not been prior criminal prosecutions is that there were not crimes.
And Trump's lawyer brought it up many times.
The implications of the court's decision here extend far beyond the facts of this case. Could President George W. Bush have been sent to prison for obstructing an official proceeding or allegedly lying to Congress to induce war in Iraq? Could President Obama be charged with murder for killing U.S. citizens abroad by drone strike? Could President Biden someday be charged with unlawfully inducing immigrants to enter the country illegally for his border policies? The answer to all these questions is no. Prosecuting the president for his official acts is an innovation with no foothold in history or tradition and incompatible with our constitutional structure.
Bush lied to Congress to induce a war in Iraq. Obama ordered drone strikes that killed U.S. civilians abroad, and Biden is actively involved in some sort of illegal human smuggling racket with the cartels, a voter smuggling racket. He's been found to be in violation of the Constitution multiple times just this year. Can all these former presidents now be prosecuted by rogue Republican DAs? Will Joe Biden be prosecuted now when he leaves office? Obviously, again, that simply cannot be the case. But the leftist opposition, Joe Biden's DOJ, is kind of making that argument.
How about President Obama's drone strikes?
So the Office of Legal Counsel looked at this very carefully and determined that, number one, the federal murder statute does apply to the executive branch. The president wasn't personally carrying out the strike, but the aiding and abetting laws are broad. And it determined that a public authority exception that's built into statutes and that applied particularly to the murder statute because it talks about unlawful killing did not apply to the drone strike. So this is actually the way that the system should function. The Department of Justice takes criminal law very seriously. It runs it through the analysis very carefully with established principles. It documents them, it explains them, and then the president can go forward in accordance with it. And there is no risk of prosecution for that course of activity.
Once again, dealing in assumptions. Well, Barack Obama may be a war criminal, but it's different, you see. So Obama benefits from presidential immunity, but Donald Trump clearly doesn't and should be a target of political persecution because I guess, I don't know, Orange Man bad or something. Completely ridiculous. I'm actually feeling pretty good about this one. I wasn't sure where these arguments were going to take us, but it seems as though the tone of the conversation is headed in the right direction. Presidents should absolutely benefit from presidential immunity. That is the, quote, current regime. It's been the regime. You cannot be expected to make difficult decisions if you are constantly operating under the fear that your political opponents will try to throw you in prison for life. And of course, there's already checks and balances in place. It's called the impeachment process. Anyways, that's pretty much what I got for you guys. Thanks for watching, and I'll see you on the next one.